Good afternoon. Welcome to the March 2026 Colorado Cancer Coalition Survivorship and Palliative Care meeting. I would like to welcome you and I would like to turn this over to Andrea.
Thank you. Hi, everybody. My name is Andrea. I'm here because we're going to be practicing language justice today, and we're going to have simultaneous interpretation in English and in Spanish so that we can all communicate in the language of our heart or how we feel more comfortable. In a couple of seconds, after I'm done saying this in Spanish, we're going to turn on the interpretation, and you're going to see a globe that is going to come up at the bottom of your screen where you're going to be able to select your language. If you don't see the globe, go to the three little dots or where it says more, and you'll find the interpretation function there. If you're not fully bilingual in English and in Spanish, please select your language so that you can fully participate of this meeting. And this goes for our presenters and facilitators as well. Hola a todos, mi nombre es Andrea. Hoy vamos a practicar la justicia del lenguaje y vamos a tener interpretación simultánea en inglés y en español para que podamos comunicarnos en el idioma de nuestro corazón o como nos sintamos más cómodos. En algunos segundos vamos a aprender la interpretación y ustedes van a ver un globo que va a aparecer en la parte inferior de su pantalla donde van a poder seleccionar su idioma. Si no ven el globo, vayan a los tres punticos donde dice más y ahí encontrarán la función de interpretación. For our presenters, please remember that Spanish is 20 to 25% longer than English. Speak at a conversational pace so that I'm able to interpret everything accurately. If at some point you're speaking too quickly, I'm going to turn on my camera and I'm going to let you know that you're speaking too quickly. I'm going to probably do this. It just means stretch your words so that I can keep up with you. And other than that, my camera will be off. And host, we can start interpretation now.
Alrighty, well, thank you, Andrea. Just a few quick announcements before our featured presentation. Happy Social Work Month to all of the amazing social workers in Colorado who do great things each and every day. The cancer plan for 2026 through 2030 is now live, so check out the coalition webpage and start thinking about how we can bring this document to life. In April 9th at noon, we will have a very informal session for our nonprofit organizations who want to come together and share best practices. In May, we're going to have two psychologists talk to us about insomnia, so all of us can glean some words of wisdom from them. And then save the date for May 20th in Pueblo with Live by Living and Lori Carden and her amazing organization. We're going to gather in Pueblo at the museum. So details forthcoming. And then finally, please save June 7th. That's National Cancer Survivors Day. So we're going to have an event like we did last year in Colorado Springs. We're still waiting to hear from Porter Hospital in Denver about their official events. And last year, Durango had something. So the hope is that they will do so again this year. So, without further ado, we acknowledge Healthcare Decision Day every April. It's April 16th, the day after Tax Day. And within the coalition, we just want to share information and help people learn as much as they can about healthcare decisions and what is beneficial. So, we asked Dave, our attorney friend, to come give us some information and to share documents and tips. So, without further ado, Dave, we'll let you introduce yourself and share your knowledge with us. Thank you so much.
Thank you, Carlin. Uh, as she was saying, my name is Dave Strousberg. I've had an opportunity to meet or speak to a bunch of you that are on this call right now. I recognize the names or see the faces where you've had questions for me about, your own things involving estate planning or health directives or those types of things as well. For those of you who don't know me, my name again is Dave Strousberg. I am the managing attorney and owner of a law firm called Wills Simplified. It's a small boutique practice that specializes in estate planning and administration. I I had gotten connected with the Colorado Cancer Coalition about a year ago. Um, uh, from my own backstory, my mother had passed away from cancer when I was a child, and that kind of informed my decision to go into the type of work that I do right now. And with my firm growing and trying to figure out more ways to get involved and volunteer, that's where I have found, the coalition, and I've been appreciative of the opportunity to speak to you guys on a variety of different estate planning topics, sponsor your, conference as well, and just meet and speak with some of the individuals that I've had the privilege of being able to do so. So today I wanted to take a few minutes to talk, as long as we're focusing on Healthcare Decision Day, talk about something that people don't often think about right away when they're thinking about estate planning. They're often thinking about, okay, what assets do I have and where do they go to? But estate planning isn't just about the financial side. Estate planning is also about the medical side, the healthcare side. It's about incapacitation as well. So I wanted to be able to share a very brief, presentation, with you guys to kind of run through some important things to be able to consider, point you in the right direction if you're starting to do your own type of research at all into this type of area. I want to make sure that I leave plenty of time for questions. I want to also say that oftentimes these questions can get to be pretty personal, obviously. So if anybody wants to schedule time with me, I never charge to talk to anybody from the coalition, at all. Happy to answer any of your questions, at all, if that would be potentially helpful. So I'm going to go ahead and share my screen. And everybody's able to see this? Yep. Thanks, Ella. Okay. So first thing that I have to say is I wouldn't be an attorney if I didn't have a disclaimer explaining every situation is different. And although I am a lawyer, I am not your lawyer, or at least at this point, yet as far as our conversation goes. So, way to take, suck the energy out of the room by having to have a disclaimer right after that. But I said today that I wanted to focus on kind of healthcare, and the healthcare planning that goes along with estate planning. And really, when you're thinking about healthcare planning, you're thinking about a few different types of things in order to make things as easy as possible for yourself and your family. First and foremost, you're trying to name people, family members or an individual or a friend, somebody that has the ability to speak for you if you can't speak for yourself. This is really important because, like with almost all estate planning documents that only go into effect if you're incapacitated or if you've passed away, at this point where something is going on from a health perspective, where you're not able to make decisions for yourself, no one can come to you and be like, hey, what did you mean by this? So it's important to do some as best planning as you possibly, can. It is no surprise that families struggle without clear guidance. Healthcare situations and sickness and hospital stays and incapacitation and all of those types of things are tough enough and they're stressful enough. They are even more stressful when your family doesn't have any clear guidance. And that leads into this idea of those proper documentation, pieces that you can have in place. They can reduce a lot of stress. They can't necessarily make the situation better, obviously, because of whatever is going on with yourself or with your family. But there is a certain level of peace of mind knowing that you have these different types of things prepared. And that's something that I hear from my clients and other people that I've worked with all the time as well. And planning is the best way to ensure that your wishes are followed. There's a lot of people that I work with or that I've spoken to that have said, well, if I was at, an end of life situation, or if I were, in the hospital and couldn't speak for myself, I know that my daughter, or I know that my mom, or I know that my, brother or whomever it is, or my friend, they know me, they'll be able to communicate what it is that I'm feeling. And maybe they have a better idea than other people, but the one thing that they don't know is what your exact wishes are. So this is your opportunity by preparing the healthcare types of documents within an estate planning strategy to share what your specific thoughts or feelings or wishes are in a given, situation. So there are four key healthcare documents, okay, that you want to be looking at when you're estate planning. And there's a fifth one that is related to estate planning that I'll share in a second, as well, and I'll explain how it's something you want to take care of with your doctor. The core documents are going to be a healthcare power of attorney. That's where you're naming somebody to be able to act on your behalf in the event that you're unable to specify or share things for you. With a healthcare power of attorney, you're naming an agent. You are considered the principal. So the agent acts on behalf of the principal, and you're giving somebody else authority to be able to speak on your behalf in those types of situations. A living will or an advance directive is an end of life decision type of document. It involves if you are in a vegetative state, if you are in a position where uh, typically two doctors have shared, that you are not coming back from the situation that you're in right now, and that you would be required to receive things like life support or artificial nutrition. And while you have capacity and you're preparing your estate plan, you have the ability to then share what your thoughts are as far as if you'd like to receive those types of, life-sustaining, treatments, and for how long and in what types of circumstances. So it's you providing specific guidance in those types of instances. One of the biggest mistakes that I see when it comes to estate planning is that people will put together advanced directives pretty specifically, and they'll also name somebody as their agent under their healthcare power of attorney that can make decisions for them. Well, inherently, those can conflict with each other. And when the situation does arise, when you would need somebody to be able to speak on your behalf. So you want to make sure that anytime you're planning or putting together these types of documents, that you specify in each one of them which of the two is going to control the healthcare power of attorney or the living will, because the causes problems all the time. I may have shared with some of you that I've spoken to individually. This was a huge problem with a family member of my own years ago that was on life support but had the healthcare power of attorney, and he had put everything together himself, which was fine. I'm not saying you have to work with an attorney to be able to do it, but it caused all the problems that working with an attorney would typically and hopefully avoid. You're going to have a HIPAA authorization. These are the types of things that you may be used to filling out anyway when you're going to the doctor, okay? And that's who has the ability to communicate with medical professionals and receive information on your behalf. You would think that that would be automatic when it comes to some of the other documents, but they're not always. So, depending on the state and depending on the forms that you're using, sometimes all these things are incorporated into one document, but typically you want to have them as all separate because they address separate things. And the other healthcare document that I want to talk about briefly, which is probably not what you would necessarily be expecting, is a living trust. Okay, setting up a trust. Most people, well, one, most people have questions about what's the difference between a will or a trust. And what I can say for the purposes of this discussion is that a will is for if you pass away, whereas a living trust is not only for if you pass away, but also if you become incapacitated. Okay. So when it comes to managing your finances, your home, your business, all of those different types of things that you would ordinarily be running on a day-to-day um, uh, situation, the healthcare power of attorney, living will, and HIPAA authorization aren't going to address management of your home or bank accounts or things like that. Whereas a living trust has the ability to do that in the event that you are incapacitated. When I talk about these types of documents, the number one follow-up question I get is about a DNR, and that's the fifth document that I was referring to, the do not resuscitate, as far as receiving CPR or different types of treatment in those types of situations. Those aren't traditionally estate planning documents. Those are documents that are signed by your physician, your primary care physician. But I work with a lot of my clients and their physicians to be able to make sure that these are put together in a way that is congruent and that matches what they want to be able to be expressing through their other healthcare related documents. So I mentioned this idea of planning for incapacitation, and you have those medical documents and then a kind of a living trust on the other side. Really, if you're incapacitated and if it's for an extended period of time, you're thinking about both of those medical and financial aspects. So from the medical aspects, remember that's only kind of half of the equation. If uh, you have minor children, if you have, like I said, a business, if you have different types of things that you're working on, and we'll get to that in a second for the financial. But under the medical, it provides for flexibility with respect to treatments and those health related decisions. And like I said before, such a big part of it is it helps resolve any potential disputes before they arise. The main one being that inherent conflict between a healthcare power of attorney document and a living will. If people have more questions about that, I'm happy to answer that after or talk to you offline about it. And then for the incapacitation aspect as well, again, with a trust, you're allowing a trustee to manage your affairs seamlessly for you if you're incapacitated. And by the way, you don't have to be incapacitated. I have lots of clients that are suffering through very strong, health related situations, and they have just decided that it's too much for them to have to deal with the day to day of managing all of their finances. So that setting up of a trust allows somebody to do that for them in that regard. Um, it addresses your care of your assets and it smooths that smooth transition. And of course, the financial aspect, if it's done correctly, it's going to work in line with your healthcare related types of documents that you have too. Um, Biggest thing that people ask me about, number one question is, who do I decide to make my healthcare agent? Okay. There's not a right or wrong answer for this, and it's a personal decision as well. And oftentimes with spouses, the spouse is naming somebody, their other spouse. Sometimes people name their children, or they don't want to name their children, or they want to talk about, is it a good idea to name our children? Sometimes people want to name multiple people to serve in a joint role to be able to do this. And that can be good because there's a sense of, collaboration around it, but it can also make things more difficult from an administrative standpoint because it's more heads trying to make decisions in highly stressful situations. So I typically say that when you're trying to choose an agent, when I'm working with my clients, is you want to start with somebody that you trust. Okay. So if the conversation is, I want to name my brother, but my brother's a great guy. I think he's a wonderful person, but I don't know if he would make the right types of decisions in this type of situation. Probably not the best choice for you then. Okay, in that regard, you want to try to choose somebody that has the ability to stay calm under pressure, and that's a hard thing because the pressure that you're dealing with when somebody is making these types of decisions on your behalf is not the same type of pressure that you might feel every day from, your job or from, just day to day, grind of life. You want to choose somebody that's going to advocate for you. Okay. It's one thing to listen to advice and to guidance and things like that you're getting from medical professionals. My experience has always been that the medical professionals that I have worked with, I respect very much, and I take what they're saying, and I think it's important. But that doesn't mean that I don't still ask questions myself. Okay, I still don't try to make sure that I have as best possible understanding as possible or advocate for myself in a way to provide some additional information. So you want to make sure that you're selecting somebody that's going to do that. Your family and friends are going to have a lot of questions. Okay, so you want to try to be able to pick somebody that can communicate well. Uh, I think if somebody says to me, well, my nephew's a doctor, do you think he'd be a good person? Sure. Yeah, I think that would probably be a good thing, a criteria to think about, somebody that has experience in these types of situations. Or maybe they're not a medical professional, but it's, my nephew isn't a doctor, but has gone through this experience before with a, cousin or something like that. That could be somebody that could be helpful as well. And then also somebody who's willing to make really, really difficult decisions. Okay. And that could have to do with the end of life. And of course, I want to make sure that, I always point to this idea that you want to make sure that your living will and your healthcare power of attorney document specify which one controls in those end of life, type of situations. Oops. So how can you kind of get started on these types of things? I hear from people oftentimes that they know that they should get these types of things done. A lot of times it's people that share it with me because they had just gone through a family member that had had to experience this. And it's always great when you can be able to get these types of things taken care of in time. Okay. But if you want to be able to be proactive as best as you possibly can, I always like to start saying, well, what does quality of life mean to you? Start thinking about those types of things because when you work with myself as an attorney, I'm not just somebody that's like, okay, who do you want to name? Thanks, we're done. I want to also have an idea or an understanding of, well, what does that quality of life exactly mean to you in these types of situations? Sometimes that can help inform other types of decisions. Are there any religious or personal beliefs that you want known? So again, you can trust people to know you, but it's a good opportunity to actually spell those out. You don't need to have the actual documents there to start listing what those things are, or at least communicate them to the people that are around you as best as possible. I don't think that you have to put these types of things together in a vacuum, or at least after everything is created. I think it's important to share with your family. So look at their perspective, let them know what they think. And then lastly, I always encourage people that if this is stuff that you have questions about, what I run into a lot of times is I know I want to do this. I have lots of questions about this. I just don't think I'm ready yet, okay, in order to be able to do it. The thing about these types of things is we never know when the appropriate time is or not time to be able to do that. So the best thing that you could possibly do is start a conversation or a consultation with a professional that does this type of work. As I mentioned earlier, for anybody that just wants to ask questions or kind of get an idea of what this type of stuff looks like at all, I don't charge for consultations with, for anybody from the coalition. And that doesn't matter if it's one time or it's three times, like it has been with a few different people that have just reached out because they have more questions. I am genuinely more than happy to be able to help. And that's it. I mean, I'm sure that Carlin and Ella and the other powers that be, have my contact information for you guys. I know that you have it because you keep reaching out to me, so that's a good thing too. But there is my email and there's my direct line, for my business as well. And I hope that you guys found this somewhat informative and helpful, and I am happy to answer any questions if anybody has any questions now, or I'm happy to also say thanks so much for inviting me to your meeting, and I am more than happy to talk to you, offline after if it's something that you want to ask about, either in the near future or later on down the road. So, how did that sound?
I think it sounded great, and we sincerely appreciate it. Before we stop recording and open it up to questions, we are the Colorado Cancer Coalition. So, can you talk about Colorado specific law? Specifically, I'm thinking about hierarchies and who makes some of these decisions.
Are you talking about as far as with the family members, specifically
Correct.
like that as
Correct.
well? So you run into a couple of different types of situations in Colorado. Oftentimes they can end up being in a situation where nobody has documents prepared at all. So you find situations where administrators from hospitals or nursing care or hospice care or things like that will reach out specifically to different types of individuals to ask to try to get the approval for who's going to serve as agent, and that is allowed after the fact in Colorado. That also makes it extremely difficult. However, that's just because it is allowed does not mean that it is a situation that you want it brought into life. Also within the state of Colorado too, with the powers of attorney, both a healthcare power of attorney and a financial power of attorney, you are looking for language where you're not necessarily only relying on discretion, okay, of the agent. You want to see as much as possible uh, in the documents themselves that speak directly towards whatever types of decisions that you want to be able to make. I've run into situations where people have had healthcare powers of attorney from other states or financial powers of attorney from other states, and they've expected them to work a certain way, and they've been rejected because there wasn't clear, specific instruction of how things were going to be able to work. There is typically a default, depending on the situation of where you're going to, that an advance directive or a living will is going to take precedent in Colorado, again, because those are your wishes, okay, over that healthcare power of attorney, but you still want to be able to ensure that you resolve whatever that potential conflict is before uh, the situation arises where it becomes necessary. And then Colorado also has the standard that if for a living will or for incapacitation or more specifically vegetative state needing to be on life support, the standard is typically that two doctors, okay, have to be able to make that declaration. And that's where the living will may come into place, or the person that is the agent under the healthcare power of attorney would come forward. Is that helpful?
That's very helpful. I think so many people have moved to Colorado at some point in their
Yeah.
lives. And so I think it's important for us to help spread the word that it's not automatically the spouse. There's no, default. And so your explanation was very helpful.
And that's a great point too, because one of the things that I hear the most when I'm working on planning with a family is, well, we just assumed that it would be the other spouse that would be allowed to make all decisions, or I just assumed it would be my daughter. That might be the person that is gone to say who can make decisions. And maybe there's a situation where, you know, one facility is allowing that more than the other, but from a legal standpoint, okay, the important thing is to be able to have the documents be able to put together. Not only from that, but there's so many situations where there's a second marriage, or spouses are divorced, or well, I guess they're not spouses anymore, but life happens as well from when you put these types of things together that have implications as well if you don't update or amend or change them. So you want to be able to make sure that you have things as current as possible and not rely on the state of, the fact that because we're spouses. A very brief example of this, I'm helping two families through probate right now, where one spouse had passed away and the surviving spouse assumed that they were going to be receiving everything because they were married. They may be entitled to it by statute, by law, but that doesn't mean that it's not going to take us a year or so to be able to hammer all of that out as far as what you would expect would happen anyway. The same type of stuff happens in healthcare related types of situations as well.
Thank you. Ella, could you stop recording?
Yeah, sure. And we have some questions in the chat, by the way.
Sure.
Absolutely.
So,